Namaskar. I am Professor Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on the new criminal laws. Today, we will be discussing some of the new crimes that have been introduced in the new laws. In Bharatiya Nyaya Sanhita, which is the substantive law on crimes in India, many new kinds of crimes have been introduced. There have been additions to some existing provisions in the sense that the dimension of that crime, it has undergone a change. So, in today's session, we will be dealing with defining new crimes part 1. So, mainly we will be dealing with abatement of crimes when a crime is committed in India, but the crime was abated outside India. Then coming to rape on the promise of marriage or mob lynchings, and we will also try to understand how the law relating to causing death by rash and negligence has undergone a change. So, first of all, we will discuss section 48, which is a new addition to the BNS. See, this provision was not there in the old Indian Penal Code. This has been introduced in chapter 4. Now, chapter 4 is a chapter which deals with all incomplete crimes. So, the inchoate crimes of abatement, criminal conspiracy and attempt, they have all been clubbed together and placed under sections 45 to section 62, and they have been all put together in one single chapter, that is chapter 4. In this chapter, we have added one new provision, that is section 48. This deals with the crime of abatement outside India for an offence that takes place in India. See, abatement can take place by instigation, by aid, by conspiracy. So, whenever a crime is abated outside India, but the crime takes place in India, whatsoever be the manner of such abatement, it would be now a punishable offence. So, what the provision says is, a person abets an offence within the meaning of this Sanhita who, without and beyond India, abets the commission of any act in India which would constitute an offence if committed in India. So, to dissect this provision, see, even if you have not committed the crime, but you have abetted the commission of such crime, and such crime was committed in India, but abatement was done by a person who was placed outside India. So, if the person was in India and if he had committed such abatement in India, it would be a punishable crime. Now, even if you are outside and if you abet the commission of an offence in India, it would be a punishable crime. There is an illustration. It says, A in country X instigates B to commit a murder in India. Now, see, A, he is located outside India, he is in some hypothetical country, country X. But what he has done, he has instigated another person to commit the crime of murder within the territory of India. So, now A would be guilty of abetting murder. See, A cannot take the plea that, see, I was at a place where the laws of India would not apply, so I should not be held guilty. See, our BNS, it has a extraterritorial jurisdiction also, and now with the specific provision in place which applies this extraterritorial jurisdiction in cases of abatements also. So, those who are planning commission of crimes in India, they would also be now in the net. So, this is a provision which allows prosecution of person who is located in a foreign country. Earlier, there was no law to prosecute a person located outside India who abets the commission of an offence in India. However, the execution of sentence outside territorial jurisdiction of the country would still be strictly governed by international treaties. It is pertinent that clause 356 of Bharatiya Nagarik Suraksha Sanhita, that is, inquiry, trial or judgment in absentia of proclaimed offender, and clause 112 of the Bharatiya Nagarik Suraksha Sanhita, that is, letter of request to competent authority for investigation in a country or place outside India, are put to use with seriousness in order to bring the offenders to justice under section 48 of the Bharatiya Nyaya Sanhita. Such people who were located outside India but they abetted the crime in India can be brought to India through the extradition process. See, section 112 of the BNSS, it deals with letter of request to competent authority for investigation in a country or place outside India. So, viewers, if in the course of an investigation into an offence, an application is made by the investigating officer or any officer superior in rank to the investigating officer that evidence may be available in a country or place outside India, then any criminal court may issue a letter or request to a court or an authority in that country or place competent to deal with such request to examine orally any person who is supposed to be acquainted with the facts and circumstances of the case. And what can that person do? They can record the statement that is made in the course of such examination. Then, letter of request to competent authority for investigation in a country or place outside India, herein, this would also require such person or any other person to produce any document or thing which may be in his possession pertaining to the case, and to forward all the evidence so taken or collected or the authenticated copies thereof or the things so collected to the court that issued such letter. Further, the letter of request shall be transmitted in such manner as the central government may specify in this behalf. Then, every statement recorded or document or thing received under subsection 1 shall be deemed to be the evidence collected during the course of investigation under this Sanhita. Under section 355 of the Bharatiya Nagarik Suraksha Sanhita, the judge or magistrate may conduct a trial of an accused in his absence if it is deemed that the personal attendance of accused is not necessary in the interest of justice, or if the accused persistently disturbs the proceedings in court. So, viewers, now you see in such cases we can also hold in absentia trials. So, this BNSS, it allows in absentia trial of proclaimed offenders, but under specific conditions. Section 356 of the BNSS mandates the court to proceed with the trial in absentia when a person who has been declared as a proclaimed offender has absconded to evade trial and there is no immediate prospect of arresting him. It also specifies a mandatory waiting period of 90 days from the date of framing of charge before commencing the trial. See, this period of 90 days, this is in a way a concession to the accused person, that is, if he wants to appear before the court, so he has now sufficient notice. See, whenever we hold trials in absentia, it is in a way compromising with the rights of the accused person. But where the person has been called to stand trial, but the person does not appear before the courts despite being called, so now he is doing so at his own peril. He is himself compromising his rights because he has a proper right of representation. He has a right to cross-question the other parties, but in case he is not there, then the trial is not supposed to wait or be deferred indefinitely. we would have to proceed in absentia, and now the accused has the opportunity within 90 days of framing of charge. He should either make himself present before the courts, otherwise the courts will proceed against him in absentia also. Then section 24, explanation 2 of Bharatiya Sakshya Adhiniyam, the old Evidence Act, which has now been replaced by BSA. In this, there is a provision regarding deemed joint trial. So what does the law say? A trial of more persons than one held in the absence of the accused who has absconded or who fails to comply with the proclamation issued under section 84 of the BNSS shall be deemed to be a joint trial for the purpose of this section. So after discussing the first new substantial crime that has been introduced under the BNS, now we move on to the next provision that has been changed, and that is a significant change regarding the law relating to rape. See, we all know that marital rape is a very contentious provision, and India does not criminalize marital rape, and the grounds that we give for non-criminalization of marital rape are that, see, women, they already have a remedy under physical cruelty under the substantive criminal law, which was the old 498A. Then women, they can also claim divorce on grounds of cruelty, and also under the Domestic Violence Act, sexual violence is a kind of violence against which a woman, she can get restraining orders against her husband, she can get separate residence orders, and so on and so forth. And then establishing rape within marital relationships, it would be extremely difficult, and there would also be the possibilities of this law being misused in the absence of any specific procedures or evidentiary rules prescribed regarding establishing or proving rape within the institution of marriage. But earlier, the age of consent for a wife, that was only 15 years, there was a window of 15 to 12 years. Even after the Nirbhaya incident, although that window, it was removed, but still there was a presumption as to matrimonial consent, and husbands, they enjoyed an exemption from criminal liability. So this was a marital rape exemption. See, the law doesn't say that a woman cannot be raped within marriage. Rape is a question of consent. The law only said that a woman who was married to a man, the husband would enjoy some sort of a exemption from criminal liability, so the husband would not be prosecuted for marital rape in case the woman was above a specified age. But earlier there was a distinction, whereas for other girls the age of consent was 18 years, for wife the age of consent was 16 years. So now what the law has done, we have changed this exception to, in the sense that now sexual intercourse or sexual acts by a man with his wife, the wife not being under 18 years of age, is not rape. Now, why did we need to bring about this change? Because in the year 2017, there was a judgment by the Supreme Court. The title of the case is Independent Thought versus Union of India. In this, there were two relevant paragraphs, para 1 and 195, in which the courts have given directions to the state that, see, we need to do something regarding this age of matrimonial consent, and it should be uniform. This age should be uniform for all women, whether they are married, whether they are unmarried. So I'll quote the relevant extracts from those paragraphs 1 and 95, in which the Supreme Court observed that artificial distinction between a married girl child and an unmarried girl child is unconstitutional. Sexual intercourse with a girl below 18 years of age is rape, regardless of whether she is married or not. So the exception carved out in the Indian Penal Code creates an unnecessary and artificial distinction between a married girl child and an unmarried girl child, and it has got no rational nexus with any unclear objective sought to be achieved. So, the court held that the artificial distinction is arbitrary and discriminatory and is definitely not in the best interest of the girl child. This artificial distinction is contrary to the philosophy and ethos of Article 15(3) of the Constitution. See, Article 15(3) talks about special laws that can be made for women and children. But when we are talking about special laws, we are talking about laws that should be made to protect them and that should work to the advantage of women. See, Article 15(3), it cannot be invoked to make a law or rather to protect a provision that works to the disadvantage of women. So, that is why what the courts ruled was that a distinction between a married woman and an unmarried woman for the purposes of determining the age of consent, such a distinction would be contrary to the philosophy and ethos of Article 15(3) as well as contrary to the Article 21 of the Constitution, which is not only about right to life, which is just like an animal existence. It talks about right to live with dignity, right to a dignified humane existence. So, the court held that exception 2 to section 375 IPC insofar as it relates to a girl child below 18 years is liable to be struck down on the following grounds. 1. It is arbitrary, capricious, whimsical and violative of the rights of the girl child and not fair, just and reasonable, and therefore it is violative of Articles 14, 15 and 21 of the Constitution of India. They also held that it is discriminatory and violative of Article 14 of the Constitution of India and it is inconsistent with the provisions of POCSO, which must prevail. See, POCSO is a secular law, which is a gender neutral law, which protects all our children against any kind of a sexual abuse. So, when a child is married, a child is a person who is below 18 years of age. So, we cannot allow any exemption to operate against the interests of such child. So, that is why now the age of consent for all women, whether she is married, whether she is unmarried, it has been raised to 18 years. Beyond 18, the husband can presume the matrimonial consent. So, women, they will not be protected against marital rape in the sense that they cannot prosecute their husbands for marital rape under BNS where the woman is above 18 years of age. But then she has got so many other remedies. If she does not want to continue with an abusive husband, so she has other remedies that she can invoke in such cases. Then there is one new provision that has been now introduced in the BNS in the form of section 69. See, viewers, this is again a provision regarding which we had certain judicial pronouncements, but this was not integrated in our statutory law. So, now when we were revisiting our substantive criminal law and we enacted the new Bharatiya Nyaya Sanhita, now was the time for us to introduce this provision by way of a statutory provision now. So, section 69, it deals with sexual intercourse by employing deceitful means, etc. So, the law says, whoever by deceitful means or by making promise to marry a woman without any intention of fulfilling the same, has sexual intercourse with her, sexual intercourse not amounting to offence of rape, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. So, what it says is that first, what has to be invoked is deceitful means. Now, deceitful means could be like the person has promised some sort of a promotion or some other favors, or when the man promises the woman that, see, I am going to marry you. But it is deceitful because at the time when the person makes that promise or to marry or to promote or any other thing, at that very time the man lacks the intention of fulfilling the same. So, the man has made such false promise just in order to obtain the consent of the woman. Now, after obtaining such consent that was obtained by a fraudulent means, the man has sexual intercourse with the woman. Now, such sexual intercourse will not amount to offence of rape. Why? Because the consent of woman is involved. But we all know that such kind of a consent is no consent under law, because it is not a free consent. So, in such cases, the accused can be punished with imprisonment of either description for a term. It could be simple, it could be rigorous, but the sentence can extend up to 10 years. So, here viewers, what is important is the deceitful means, and deceitful means has been defined in the explanation as including inducement for or false promise of employment or promotion or marrying by suppressing identity. See, caste, community, religion, these are important considerations while marrying. So, if a man misrepresents himself to belong to some other caste, like he might represent that, see, I belong to your caste or the religion which the woman professes in order to get her consent. So, now this is all a false representation, and a consent that has been obtained on the basis of such deceitful means will not operate as consent so as to absolve the accused of his guilt under the law. See, section 69, it seeks to penalize those who use deceit or false promises of marriage, promotion or employment. See, while rape involves total absence of women's consent to sexual intercourse, offence under this section is about procuring her consent, but the consent has been procured through deceitful means, false promises. We already have judgments. In the year 2003, in Uday versus State of Karnataka, the Supreme Court has said that the consent given by prosecutrix to sexual intercourse with the person with whom she is deeply in love on a promise that he would marry her on a later day cannot be said to be given under a misconception of fact. A false promise is not a fact within the meaning of the code. There is no straitjacket formula for determining whether consent for sexual intercourse was voluntary, whether it was given under a misconception of fact. So, in the ultimate analysis, the test laid down by courts provide at best a guidance to the judicial mind while considering a question of consent, but in each case the court must consider the evidence before it and surrounding circumstances before arriving at a conclusion, because every case has its own peculiar facts. Similarly, in Yedla Srinivasa Rao versus State of Andhra Pradesh, what happened? The accused never had the intention to marry her from the very beginning, but he kept on promising that he will marry her till she became pregnant, but he had no intention whatsoever of marrying her. In case of Jayanti Rani Panda versus State of West Bengal, see, a fully grown woman, if she consents to the act of sexual intercourse on a promise of marriage and continues to indulge in activity, it is an act of promiscuity on her part. But in all such cases, you have seen the determining factor would be the intention of accused at the time of act. If he never intended to marry, he is guilty of cheating. Therefore, it depends upon case to case, depending upon facts and circumstances of each and every case. So, section 69 is a provision which will protect our girls against being raped by deceitful means, by luring them with false promises of marriages and promotions. So, viewers, this will be all for now. In the upcoming episode, we will deal with certain other crimes which have been introduced in the BNS. Thank you.